Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Thank you for joining my YouTube channel if you've subscribed, and if you would like to contact me, and I do give free consultations. If you are having problems with your mortgage, let me know what's going on. I am not an attorney and I do not give legal advice, but I can tell you that being pro se and fighting my own foreclosure, what I would do in your situation. So hit me up if you need some assistance, and I will certainly try to help you. If not, I will collaborate with other people that are also in foreclosure and fighting as well. So today we're going to talk about quiet title actions again, because so many of you are doing this and are struggling, and hopefully this video will be informative in helping you make your quiet title actions better so that they survive dismissal. So let's talk about that. If you're formatting your complaint, you want it to say verified complaint as your title for your complaint for quiet title, as we can see here. The first section is parties, where you want to say who you are first, and then the other people you're suing. In this case, the Department of Housing and Urban Development, HUD, is who she's suing for her reverse mortgage. And then you have your jurisdiction and venue section, where you explain why the court has subject matter jurisdiction. In this case, it is a federal court, and federal court has jurisdiction when it comes to HUD. And then your next section is your factual allegation section. And this is the part that everybody struggles with. You need to make sure your things that you talk about is in chronological order. Everything from the very beginning should be numbered. So you see, even party section have to be numbered, right? As you see here, number 1, parties. So as you're going through, number every single paragraph, because they have to answer every single paragraph. Okay, so when you do your factual allegations, you start in chronological order. When you got your mortgage, you want to put your exhibits in there respectively. What happened in this case, and a reverse mortgage, death of parents. Then we get into the title part, why you want to quiet the title. Now, in this case, there was some deeds of trust that were recorded and assignments, and the assignment is invalid. And in this case, the assignment was invalid. Let's take a look at that real quick. This is an assignment of deed of trust that was executed. If you look at the date, you want to always look at the date it was executed. In this case, it was March 27, 2024. And in this case, it's saying that the assignor was Financial Freedom Acquisition, and MERS as a nominee for this, giving it to HUD. And interestingly enough, this Financial Freedom Acquisition, it ceased operations in 2009. And another exhibit in this was this right here, where it says Financial Freedom by the FDIC receivership, dated March 19, 2009, shows when it ceased to exist. So there's that. Let's take a look at another assignment so you can see what I mean by breaking the chain of title. Okay, so here is a different assignment of mortgage that says that was recorded in 2011. As you can see right here, on October 11, 2011, it was recorded. On October of 2011, they're saying Option 1, Sand Canyon Corporation, formerly known as Option 1, is trying to assign this mortgage to the Soundview Home Loan Trust 2006 OPT1 Trust. But in 2011, it didn't exist. Let's take a look. Okay, here is proof they don't exist. And again, you got to attach proof if something doesn't exist to your quiet title action. Something that is tangible and real, like this case is a Chapter 13 bankruptcy case. And it's the declaration of Dale M. Sugimoto as president of Sand Canyon Corporation. And to get to the end of this, where it matters, basically executed on March 18, 2009, And it says here, Sand Canyon also does not own any residential real estate mortgages. Sand Canyon's present business involves dealing with litigation claims, including title issues or litigation related to servicing prior to the sale of its rights to AHMS. So basically, it's saying, accordingly, Sand Canyon is no longer engaged in the servicing of residential mortgages. It has no servicing rights. And this was in 2009. So you'd really think that in 2011, when that assignment of mortgage was made, that they had no authority to assign it. And so this is what I talk about. A quiet title action is you have to be very specific when you're pleading your facts in your complaint. And so you want your exhibits to show what you're arguing so that when you get down to your cause of action, they make sense. Let's take another look. Okay, so when you get past the factual allegations, you go to your cause of action. And in this case, your cause of action is quiet title. And it says who it's against. Against HUD and the Secretary of Housing and Urban Development. And then you want to say that, you also want to say that plaintiff realleges and incorporates by reference paragraphs 1 through 50 as fully set forth herein. In other words, this is the part of the factual allegations section before that. You want to include that in this. That's why it says that. And basically this says this action is brought pursuant to 28 U.S.C. 2410 to quiet title to real property against the United States, where the United States claims or asserts a lien or other interest. Defendants HUD and Secretary claim an interest in the property based upon a purported March 27, 2024 assignment of deed of trust and an alleged HECM reverse mortgage loan. As alleged herein, the purported March 27, 2024 assignment is void or alternately voidable because it was executed by and through an entity that lacked legal capacity and any assignable interest at the time of assignment and therefore failed to convey any enforceable lien interest to HUD. So, further, defendants have failed to demonstrate a valid, continuous chain of title establishing HUD as present beneficiary or entity entitled to enforce the deed of trust encumbering the property. The continued assertion by HUD of lien enforcement and foreclosure authority based on a void or unenforceable assignment constitutes a cloud on plaintiff's title and interferes with plaintiff's lawful ownership and use of the property. Plaintiff seeks in judgment quieting title in her favor and declaring the HUD has no valid enforceable lien or right to foreclose upon the property. And then in this case, since it's a federal agency, count 2 is Administrative Procedure Act ultra-vires agency action. Again, plaintiff realleges and incorporates by reference paragraphs 1 through 57 as if fully set forth herein. And again, these are agency officials. And defendants' actions in asserting a lien enforcement authority, accelerating the alleged reverse mortgage debt, and threatening foreclosure constitutes final agency action subject to judicial review under the APA. Defendants' actions were arbitrary, capricious, and abuse of discretion and otherwise not in accordance with the law in violation of 5 U.S.C. 7062A because defendants relied upon a void or unenforceable assignment and failed to establish lawful authority to enforce the deed of trust. Defendants further acted in excess of statutory jurisdiction, authority, or limitations and without observance of procedure required by law in violation of 5 U.S.C. 7062C and D. Defendant's conduct constitutes ultra-vires agency action because no federal statute or HUD regulation authorized HUD to enforce or foreclose upon a deed of trust absent a valid present lien interest and lawful entitlement to enforce. Plaintiff has suffered and continues to suffer irreparable harm as a result of the defendant's unlawful conduct, including clouded title, threatened foreclosure, and deprivation of due process. Plaintiff seeks declaratory injunctive relief, setting aside defendant's unlawful actions and prohibiting further enforcement activity absent lawful authority. And then the count 3 was a declaratory judgment where she's asking the court to declare that that lien is no longer enforceable. And that's pretty much all the cause of action that she has. She has her prayer for relief last. She's asking for relief, because you got to ask that. And then she submitted it. Okay, after your prayer for relief section, you want to sign a verification right here. And you should get it notarized. Now, she did get it notarized. And then you have your exhibits. You need exhibit cover page for each exhibit. So, got a legal description there. Exhibit B would be the deed of trust. And again, this is just to kind of show you how these quiet title actions are put together, so you get a good idea. Exhibit C is the second deed of trust. Make sure all your exhibits are clearly, you're able to read them clearly. And then the rest of the exhibits have to do with like the assignment and the fact that in this case, financial freedom acquisition, showing the termination right here. As you can see, I don't know if you can see that very well, but you can see, let's see right here. And this is actually from HUD itself. It's saying when it went out of business. See right here, 3/17/09 is when it went out. And then plus the other stuff. And then the FDIC showing IndyMac took it over. As you can see here, March 19, 2009. So as long as your quiet title action has proof that there is a break in the chain of title, as long as it's outlined correctly and that you have your exhibits all in order, you should survive a motion to dismiss in your claims. So I hope this was helpful to a lot of y'all out there fighting foreclosure. And again, if you have any questions or comments, you can leave them below. And as always, everyone have a blessed day.